Hey everyone, welcome to the show where we discuss current legal events and legal hot topics. So I have practiced law now for the last 15 years as both a litigator and a regulatory attorney. So the purpose of this show is to provide non-lawyers with a bird's eye view of today's legal climate and the inner workings of our legal system from the perspective of an experienced attorney, such as myself. So within the span of 1 week, our United States Congress and the United States President signed comprehensive gun control legislation into law. However, just a few days later, the Supreme Court of the United States issued a landmark decision in which it expands the Second Amendment right to bear arms to include publicly carrying a handgun for the purpose of self-defense. And so we're going to talk a little bit about why that is considered an expansion of the Second Amendment, and also talk about the legal foundation of that opinion and how it may impact the gun control legislation that was just passed into law. But before we do that, let's first take a look at this clip.
This expands the Second Amendment right. What we don't know is if it completely eliminates the possibility for any sort of gun regulation. I am just working my way through the opinion. It is possible that red flag laws may still be intact after this. But any sort of regulation that tells people what kind of gun you can carry and where you can carry it, as long as you say you're doing it for self-defense, it's very hard for me to imagine how any of those could be upheld anymore.
Regardless of which side of the Second Amendment debate you fall on, this Supreme Court decision does two things. One, the opinion explicitly states, for the first time any opinion has ever stated this, whether it be a Supreme Court decision or a Circuit Court decision, which is a lower court, for the first time the Supreme Court is holding and is ruling that the Second Amendment protects an individual's right to carry a handgun in public for the purpose of self-defense. This is a landmark decision because this is a novel ruling. And second, it changes the standard of review that courts use to determine whether gun regulations are constitutional, whether it be at the state or congressional level. So honestly, I think the decision is problematic for those same two reasons. And regardless of which side of the Second Amendment debate you fall on, I think you should find those two things problematic as well. And this is why. So the three justices in the dissent, that's the minority opinion, which means they don't agree with the court's opinion, provided some very disturbing statistics in the dissent. So right on the first page, we read that as of the day that the dissent was written, there have been 277 mass shootings in this country since January 1st of 2022. That's more than one mass shooting a day. And this information is available at www.gunviolencearchive.org, which is cited as the source of this information in the dissent's opinion, in what we call the dissent, which is the minority opinion. Even more disturbing, we read that gun violence has replaced automobile accidents as the leading cause of death among children and adolescents in the United States. In the past, the leading cause of death of children and adolescents in the United States was automobile accidents. In the present, in June of 2022, the leading cause of death among children and adolescents is gun violence. That is available in the New England Journal of Medicine, and that is the May 19, 2022 issue. that is an extremely disturbing statistic. Now, if those statistics weren't enough for you, there's another main cause for concern relating to the majority opinion, which is that it disregards the traditional legal analysis and standard of legal review that courts have traditionally and historically used to determine whether gun laws or regulations were within the bounds of the Constitution. So the standard that I'm referring to is called the means-end scrutiny standard. And means-end scrutiny is a legal term of art. It is a type of legal reasoning whereby courts will use means-end scrutiny to weigh a state's, typically a state's, interest in regulating guns versus the effect that it has on the individuals that are being regulated. So the crux of the means-end scrutiny is trying to determine whether the state has a compelling interest in regulating a constitutional right. If that first question is answered in the affirmative, then we also have to look at whether the state narrowly tailored its infringement or its regulation so that it will infringe on the constitutional right in the least intrusive manner. Now, the problem with this landmark decision is that it throws this whole line of reasoning out, which this is the legal reasoning that applies to pretty much any constitutional issue, not just the Second Amendment. Means-end scrutiny is, at least when I went to law school, which honestly is unfortunately like 20 years ago, but almost 20 years ago, not quite. But in any event, means-end scrutiny, that is how lawyers determine whether laws infringe on constitutional rights. The problem with the majority opinion is that instead of engaging in this means-end scrutiny analysis, which is the standard for how judges do this, number one, and then two is also most legislators also will engage in cost-benefit analysis when determining whether certain legislation should be enacted, which is again something else that you will be able to read in the dissent, which writes extensively about this means-end scrutiny, the importance of means-end scrutiny, and the impact of the highest court in our land simply abandoning the legal analysis and then replacing it with what is termed as a historical analysis. And now the problem with that as a lawyer is that I'm not a historian, I'm a lawyer. And so any standard that negates a legal analysis and replaces a legal analysis with a historical standard, with some type of historical analysis that's very murky and not very transparent, is problematic from the perspective that if you watch the trailer, you'll know that in any type of democratic system of government, you have to have uniform laws because in order for lawyers to be able to predict whether someone is right or wrong or whether something is legal or illegal, we have to have what we call precedent. So we can look at that and say, hey, this is how this has always been done in respect to the law. And so if you do something to the contrary, then you're probably going to be outside the bounds of the law. And if you stay within these parameters, you'll probably be within the confines of the law. Unfortunately, what this opinion does is it removes all of that certainty for any lawyers that practice, at least in the Second Amendment field so far. But again, it's also problematic because means-end scrutiny is simply a constitutional standard. To kind of illustrate the impact of this decision, I have read that the law firm that actually won this case is no longer practicing in the Second Amendment field anymore. And I'm not saying why that is because I don't know them. I haven't mentioned the name of the firm. All I'm saying is that from my own personal perspective, it seems like it'd be difficult to practice in that area because the legal analysis has been removed. And there's no law without legal analysis. You can rubber stamp it and call it law, but an apple is an apple and an orange is an orange, and history is history and law is law. History is not law, even if you call it law. So those are my concerns about the Supreme Court's recently issued Second Amendment opinion. If you have any thoughts or comments, or even if you have any questions about legal analysis and why this opinion seems to depart from the traditional legal analysis that's been used by lawyers for, honestly, centuries. So with that being the case, if you found this interesting, go ahead and subscribe. If you have questions, leave them below. I will leave a link to the case. At the very least, I'll leave the name of the case where you can read the majority opinion if you would like, and you can also read the dissent. And stay tuned for our next episode where we're going to be discussing another Supreme Court opinion, an extremely hot topic, the Supreme Court's overruling of Roe v. Wade. So stay tuned.